Hi, everyone, and welcome to the third webinar in our series looking at key themes in employment for 2022. I'm Adam Rice, one of the Knowledge Council in the employment team at Travers Smith, and with me today is Shani Edwards, one of our associates. Today, we're looking at employment contracts and changing terms and conditions. So what do you need to be thinking about if you're drafting an employment contract or reviewing your contracts or looking to change terms with your employees? I'm going to look at contracts to begin with. And I think it's fair to say, isn't it, Shani, that one of the key things coming out of 2021 is the rise in remote and hybrid working. So I wondered if you want to start with a few thoughts on how that might impact on employment contracts.
Yes, thanks, Adam. So following the winding up of the furlough scheme last year, recruitment is back on the agenda for a number of employers, and many businesses are also taking the opportunity to review employment contracts and offer letters. At the same time, we find ourselves in a very different world, and it looks like some form of hybrid working is going to continue for some time. So it's really important to undertake any review of employment contracts with that in mind. But before we go into hybrid working considerations, you'll probably remember that nearly 2 years ago now, in April 2020, changes to written particulars required in contracts for workers and employees came into effect. Given that this was at the height of the pandemic and the very start of the furlough scheme, it fell off the radar a bit. So if you are reviewing employment contracts for compatibility with hybrid working, you might also want to ensure that they're compliant with those requirements that came into effect back in April 2020. So on to hybrid working considerations. Obviously, there are no right or wrong answers, and we know that every business is approaching hybrid working differently, but we just wanted to run through some things to bear in mind and look out for. So employment contracts should include an employee's place of work or where they are required or permitted to work. And typically, contracts will just include the business address of the employer. But if the ratio of office working to remote working has shifted, or if employees are permitted to work from different locations, it might be worth giving some thought to this. But also, if the intention is to return to the office, you might want to consider including wording in the offer letter that the place of work is temporarily varied to be remote, but it's usually the office. But having said all of that, some employers do prefer just to have a policy that covers place of work, especially if things are up in the air with hybrid working, rather than inserting new wording into employment contracts. And one of the new changes that came into effect back in April 2020 was that where an employee is required to work outside of the UK for more than 1 month per year, their employment contracts should include any conditions that are related to their non-UK work. And as part of the shift towards hybrid working, you've probably already considered whether you want to allow employees to work abroad and what restrictions or limits that you'll need to have in place. Obviously, once you've considered tax, payroll, and immigration angles as well. And if employees are permitted or required to work abroad, and there are conditions attached to their overseas work, this can also be factored into employment contracts. And finally, you might want to take a fresh look at restrictive covenants to ensure that they work and they're appropriate in a hybrid world. For example, some non-compete restrictions are tied to a particular geographic location, for example, within 10 miles of a certain location or where the business operates. But with people working remotely and moving further away from offices, a non-compete limited by a geographic location might no longer be appropriate, and there could actually be better ways of protecting the business. But there have been some other recent developments around non-competes that are worth bearing in mind, haven't there, Adam?
Yeah, that's right. Thanks, Shani. There's actually been a government consultation on some possible reforms to the law on non-compete clauses. So when we're talking about non-competes, I'm sure most of you know, a non-compete clause is really just a clause in the contract that says the employee can't go and work for a competitor or can't set up a competing business once they've left your organization. Now, coming out of the pandemic, one of the things the government wants to encourage is obviously innovation and competition to help with economic recovery. And they're worried that these types of non-compete clauses are actually counter to that because they restrict competition and therefore restrict innovation. So the consultation was published back in December 2020, and it looks at a couple of different reforms to non-competes. The first thing the government is considering is actually a total ban on non-compete clauses altogether. So you'd no longer be able to say in the contract that the employee can't go and work for a competitor. Now that, to me, seems like quite a big step from the current position. So perhaps seems unlikely to happen in practice, but it is something the government has put on the table. The second thing the government's considering is really putting some restrictions around the use of non-competes. And the main one here would be a requirement for the employer to pay for the non-compete. So if you've got a non-compete clause that runs for, say, 6 months after termination, the employer would have to pay something like 50 to 60% of salary during that non-compete period. Now, that's unusual in the UK. Some employers do that already, but it's not a requirement at the moment. It is required in some other European jurisdictions. So you do see this happening in France and Germany, Italy and Spain as well. The idea is that if you're required to pay for the non-compete, you'll think twice about whether you really need it. Now, this government consultation actually closed back in February last year. And so we understand the government is still thinking about whether they're going to take these reforms forward, and if so, how they're going to do that. So it's definitely something to keep an eye on in 2022. But regardless of all of that, as Shani said, it's always a good idea to keep your covenants under review, either periodically or when something changes. So we often find that covenants get overlooked if someone gets promoted, for example, or they move into a different role, or something in the business itself changes. So you acquire a new business or you expand into a different area, or ways of working change, like Shani mentioned, people working more remotely or in a hybrid way, and how does that impact on your covenant? It's a good idea whenever you've got any of these changes happening to go back and look at your covenants to make sure that they still work for your business. Okay, over to Shani for another interesting case about benefits in the employment contract.
Thanks, Adam. So I'm going to walk through the case of Amdocs Systems Group Limited and Langton, which really highlights the importance of drafting when it comes to what an employee is deemed contractually entitled to under their employment documents. And in a nutshell, in this case, Amdocs was found liable for income protection that was not actually covered by the insurer. But let's take a step back and consider the facts here. And the facts cover an extended period of time, so I'll try to walk through things chronologically. So Mr. Langton commenced employment with CSL Limited in 2003. And when he first started, he received an offer letter, an employment contract, and a summary of his benefits. The offer letter and the summary of benefits included details of an income protection payments, which I'll call IPP, that were payable under a long-term sickness scheme. And these documents made reference to an escalator on the IPP of 5% per year after the first 52 weeks. The summary of benefits document also stated that CSL Limited had an insurance plan that covered IPP and gave the name of the insurer. So we're going to skip to 2009 now, and Mr. Langton was sadly diagnosed with a long-term illness and started to receive IPP. Fast forward again to 2015, and Mr. Langton's employment transferred from CSL Limited to Amdocs. And after the transfer happened, Mr. Langton realised that the escalator, that 5% escalator, hadn't been applied to his IPP. And he raised this with Amdocs and was told that the escalator had ceased in 2008 when it was removed from the company's insurance cover. Mr. Langton then brought a claim against Amdocs for unauthorised deductions from wages on the basis that he was entitled to the 5% escalator that was mentioned in the offer letter and benefits summary that he received when he first started employment in 2003. And the Employment Tribunal upheld Mr. Langton's claim and found that even though there was a new policy in place that didn't cover the escalator, Mr. Langton had a contractual entitlement to the escalator under his offer letter, benefits summary, and employment contract. And although the benefits summary did make express reference to an insurer and a policy, this wasn't actually enough to show that his contractual entitlement was to his employer obtaining income protection cover under an insurance policy and providing him with the benefits payable under it. So Amdocs then appealed the tribunal's decision and argued that the offer letter, employment contract and benefits summary should have been construed to show that the obligation was limited to the amount in respect of which the employer had cover. But the EAT dismissed Amdocs' appeal and observed that under existing case law, where there is uncertainty as to whether an employer's obligation to provide benefits should be limited by reference to the insurance cover, ambiguity will be resolved in favour of the employee. The EAT also observed that to effectively limit an employer's commitment to provide benefits, the contractual documents, i.e. offer letter, employment contract, should unambiguously and expressly make it clear that cover is limited to cover under the insurance policy. So what does all of this mean in practice? Well, there are a few takeaway points here. The first is that whilst reviewing and updating contracts for new joiners, it's also important to consider the terms and conditions for existing employees, especially where there have been transfers. The second is to consider how benefits are communicated to employees. In this case, Amdocs and CSL Limited didn't make it clear that benefits were limited to the insurance cover in place, and that as the employer, they had the flexibility to change the insurance policy. If this is the intention, it's important to make it clear that insurance benefits are subject to the rules of the scheme in place. And finally, employment contracts can signpost other documents, and where further information is contained in insurance policies or an employee handbook, an employment contract can cross-refer to those other documents and let employees know how to access them. So that's all I have on Amdocs, and I'll hand over to Adam now to go through a new regime for regulated firms.
Thanks, Shani. Okay, so this new regime won't be relevant for everybody. It's only relevant for employers in the financial services industry, and it's really for investment firms that are regulated by the FCA, the Financial Conduct Authority. If that's not you, you can switch off for a few minutes, but if it is, this will be relevant. So the FCA introduced a new regime this year, which is called the IFPR, or the Investment Firms Prudential Regime. And this is all about firms making sure they've got appropriate measures in place for sensible risk management. And it came into force from the 1st of January this year. Now, the bit that's relevant for employment contracts is that there are some new rules around bonuses. And what the new rules effectively say is that where you're paying out a bonus, you've got to be able to adjust the amount before it's paid out, or actually claw back the bonus, recover it from the employee, if the employee is discovered to have done something wrong. So either they have breached the FCA standards of fitness and propriety, or they've contributed to a significant financial loss to the firm. Now that's called malice and clawback. So where you're adjusting the amount of the bonus after you've awarded it, but before it's actually being paid out, that's called malice. Clawback is obviously where you've already paid out the bonus, but you're having to recover it from the employee. So what you need to do is to make sure that your contractual documentation includes provisions that allow you to apply malice and clawback. And I should say, this applies not just to cash bonuses, but it applies to any type of variable remuneration. So it covers things like carried interest and profit share schemes. So it applies to employees as well as LLP members. And we've been working with lots of clients to put in place documentation to make sure they've got the power to apply malice and clawback in their bonus scheme, the employment contract, or the relevant documentation. Now, you need to think about this both for existing employees as well as for new hires. And that probably leads us nicely to the next section, which is all about changing terms and conditions.
Yes, thank you, Adam. So now on to something that has been in the news a great deal over the past year or so. You'll have no doubt read about employers such as British Gas varying employment terms through a process called fire and rehire. And this is a practice that involves terminating an employee's employment and then reoffering them their job on new, usually less employee-friendly terms. So it's essentially a way to vary terms and conditions. The starting point for changing terms is to seek an employee's consent. Express written consent is usually the safer option rather than implied consent, and employment contracts often include a clause that sets out how a contract can be varied, for example, in writing with 1 month's notice. There are risks if an employer goes ahead and makes changes unilaterally without obtaining consent. For example, an employee could bring a breach of contract claim, or they could resign and bring a constructive dismissal claim. And where employees do not consent to changes, fire and rehire is an option. But this approach is not without risk, and there could still be an unfair dismissal claim. But what it does is it cuts out the risk of a potential breach of contract claim. Now, last year, the government confirmed that it does not plan to ban fire and rehire practices at this stage, but it also said that nothing is off the table. And the government's confirmation came after a report by ACAS, and as a follow-up to its report and in response to the media spotlight, ACAS published new guidance for employers on changing terms, including advice on dismissal and re-engagement, aka fire and rehire. And as with any dismissal, there must be a fair reason and a fair process. Employers considering firing and rehiring should consult with the relevant employees about the proposed changes to terms and conditions and the reasons behind them. There's also a collective consultation requirement that applies where 20 or more employees are dismissed in a 90-day period. The ACAS guidance recommends that employers do not introduce a proposal to fire and rehire too early in the consultation process, as this may undermine discussions with employees. But this could create a tension with the collective consultation rules. This is because if fire and rehire is one of the possible outcomes of the process, then this would need to be disclosed from the outset under the collective consultation rules, rather than waiting until later in the process. Now, as expected, we've started to see some litigation around fire and rehire. The High Court recently granted the Union of Shop, Distributive and Allied Workers, USDAW, an injunction to prevent Tesco from firing and rehiring employees. And the background, in a nutshell, is that in response to a reorganisation, which saw employees relocated from one distribution centre to another, Tesco offered the relocating employees the difference in value between their old contracts and their new contracts, and this was referred to as retained pay. This was drafted as a contractual entitlement in place for as long as each individual was employed by Tesco in that role, and the collective agreement said that it would be a permanent feature. So when Tesco tried to fire and rehire the employees to remove the entitlement to retained pay, USDAW brought a claim in the High Court. And the High Court held that it was appropriate to imply a contractual term preventing Tesco from terminating an employee to remove their right to retained pay, and also granted an injunction. Now, this is obviously a very fact-specific case, because the drafting of the entitlement made it clear that the provision was meant to be permanent, which is why USDAW applied for a declaration that the employment contracts that contained this retained pay provision were subject to an implied provision that prevented Tesco from dismissing and re-engaging people to remove the provision. It doesn't mean that employers will automatically be able to stop fire and rehire in other cases. And so we'd be very surprised if this is the last we hear on the matter, and no doubt we can expect more fire and rehire cases in the future. But to conclude, there are many considerations to take into account when proposing changes to terms, and specific advice should always be taken, preferably at an early stage. But the ACAS guidance is definitely helpful reading for any employer who is thinking about making changes in the future. And now on to Adam for another case.
Okay, so the last thing we wanted to mention today was another case on changing terms and conditions, but this is one where you've got a trade union in place. And this is the case of Costello and Dunkley, which went all the way to the Supreme Court last year. Now, where you've got a recognised trade union in place, changes to terms and conditions are generally negotiated with the union under what's called a collective bargaining agreement. And there's a law that says, as an employer, you can't sidestep that collective bargaining agreement by trying to do deals with employees directly. So you can't go to employees and make a direct offer to them if that would induce the employee to step outside of the collective bargaining. And that's exactly what happened in this case. So the employer had a collective bargaining agreement in place with a trade union, and that agreement provided that pay rises would be negotiated annually with the union, and the agreement also set out a process for those negotiations to take place. But during negotiations for 1 year, the union rejected the employer's pay offer. And so the employer then went straight to employees and made the same offer to them. And that included a pay rise as well as a Christmas bonus and some other changes to terms and conditions. Now, some of the employees signed up to that offer, but other employees brought a claim saying that this was an unlawful inducement to sidestep collective bargaining. And the case went back and forth a little bit, but the employees ultimately won their case in the Supreme Court. Now, the crucial thing here was the timing. The court said that the offer was an unlawful inducement because it had been made too early in the process. It had been made before the collective bargaining process had been exhausted. So all that had happened at this stage is that the employer had made an offer, the union had rejected that offer. The court said there was still a lot of scope for further negotiations and a lot of scope for the parties to actually reach an agreement under the collective bargaining process. But what the court did say is that once that collective bargaining process has been exhausted, if you don't reach an agreement by that stage, you can at that point go and make an offer directly to employees, and that won't constitute an unlawful inducement, because if you've tried all you can under the collective process and you don't reach an agreement, then there's no inducement for employees to step out of that collective bargaining process, because there's just simply no agreement at the end of the day. What this really means in practice is this really a timing point for employers. So you'll need to make sure that you have exhausted your collective bargaining process before you try and do a deal with employees. And where that can be really tricky, I suppose, is if you're having to make changes to terms and conditions quickly, but you've got quite a long, protracted bargaining process and several hoops to jump through before you can get there. So I guess one thing to be thinking about now would be looking at your collective bargaining agreement and seeing if the negotiation process can be streamlined with the union. Well, that's all we were planning to cover today, and that essentially brings to an end our series on key themes for 2022. We hope you found it useful. If you've got any questions, please get in touch. Our details are on the website. And that just leaves me to say thank you very much for joining us, and we hope to see you soon.